Welcome to EPG Pathshala. We are going to do a module on Women and Labour Laws 2. If you have already gone through Labour Laws 1, you would be able to bring this together in a more coherent format. This is part of the course on Gender and Social Work. I'm Dr. Shuli Kumar, Associate Professor, School of Social Work, Tata Institute of Social Sciences. The topics that are going to be discussed in this particular course are labour laws specific to women in India, gender differences and gender inequalities that are present in the laws, women's work as defined within the law and their limitations for women in unorganized sector, laws on sexual harassment and violence against women, and a summation of the same. So let's look at specific laws for women in the current context. We will look at maternity benefit because that was something historically much debate happened, and the beginnings of labour laws specific to women really emerged in India. Protective legislation for working women have always been viewed as a double-edged sword, because laws for providing women with better working conditions in response to their specific needs have often been used against them, and at times become an obstacle to their work opportunities. And that is something critical that we need to keep in mind. On the one hand, women are valorized as caregivers, mothers, and therefore that role should be protected. While on the other hand, the employers tend to not hire women if they are married, or they are in a reproductive age, or they have decided to have a child, and at that point sometimes the hire and fire policy comes into play. So it's like a double-edged situation in which women keep negotiating all the time, even during the current context. The introduction of maternity benefit and the ban on night work for women in particular are often seen as a cause of retrenchment of women, as well as restriction on the recruitment of women within the industry. So there is this ban on women to work at night. So a lot of employers prefer to employ men rather than women. So again, it perpetuates a kind of gender inequality within the world of work. In 1990, the ILO laid down in the Maternity Protection Convention various maternity-related entitlements for women workers. That is, 12 weeks of leave with cash benefits to ensure that the mother can support herself and her child during this leave, protection against dismissal during the leave period, daily breaks for breastfeeding the child, and protection of the health of the pregnant and breastfeeding woman and their children from workplace risks. This was the first time perhaps that women were recognized as individual and as individual workers. So this ILO convention in fact really flagged very critically for the world society that women need to be seen largely independent of families and households. The first ever Maternity Benefit Act was passed in 1929 by the then Bombay Legislative Assembly. So the impact of the ILO convention was that there were a lot of discourses, debates, as well as engagement within the women's movement as to what it entails within the country. And in 1929, the first Maternity Benefit Act was therefore passed by Bombay Legislative Assembly. It is a well-known fact and often very proudly proclaimed that Maharashtra and within that Bombay has been a pathbreaker in adopting many of these rights-based laws for women. And this was one of the first steps that Bombay had really taken. Debates for the act, however, showed a patriarchal mindset of the well-meaning labor representatives and other supporters of this bill. So the debates were very important, and we need to look at those debates. What were they saying when they were saying that women need to be given maternity benefit? Arguments for the For the need of the act centered on the women, the producer of future laborers of the society, and so that she could discharge her sacred function of motherhood and bring down the high rates of infant mortality prevailing at that time. So essentially the whole idea was propagation of and production of labor for the industrial society. So women were seen as such producers, and these were couched in cultural constructions of motherhood and child rearers and caregivers. Her interests, her needs, and her rights were still considered irrelevant since she existed only as a reproducer of the next generation of workers. So whatever discussions were happening, essentially they were seen in the context of not rights, but so-called protective processes, and more so protecting her reproductive functions so that she continues to produce labor for the continuation of industries and profits generated therein. Gender debates again on maternity benefit, we really need to look at this because they also continue to form a bedrock of new legislation within the country. Some of the arguments hinged on the question as to who would pay the cost of social reproduction. So there was this whole domain of argument that happened that, well, if she is producing children, then it's the husband who should be responsible to ensure that she gets adequate compensation for not coming for work. But there were many who said that the responsibility of the husband will become very difficult for the family because the husband is not paid very well anyhow. The mill owners and the opponents of the bill also depicted that working class women, because all women were not working, working class women are shrewd and devious, and they perpetuated a myth that she would produce false certificates to say that she is pregnant and she is going to have a child and go back to her village and waste a lot of time and use that money in a very different and unethical way, which was another argument that was given. Some supporters of the bill, however, like Dr. B.R. Ambedkar, argued that the burden of this ought to be largely borne by the state, that is the government, because the conservation of the people's welfare is primarily the concern of the government. So he brought in the whole domain of the welfare state at that point to say responsibility of looking after the citizens of a country lies with the state or the government of that particular country. So that was another discourse that got generated in terms of the rights of the women workers. In the end, the act empowered the government not only to frame the rules governing the scheme, but also to inspect violations. So after the Bombay Provincial Legislature passed the Maternity Benefit Act in 1929, 12 other provinces, because at that time there were no states, they were provinces, they also passed similar bills. The central legislation also passed, central legislature also passed the Mines Maternity Benefit Act in 1941, the Employees State Insurance Act in 1948, the Plantation Labor Act in 1951, and finally it was all these acts were consolidated in one Central Maternity Benefit Act, which continues to operate today. The present law for maternity benefit, which was enacted in 1961, extends to the whole of India and applies to mines, plantations, factories and shops wherein at least 10 persons should be employed, and all establishments come within the purview of this particular act. There is no wage limit to be covered under this particular act. It is not applicable to employees working in factories and other establishments. So it largely governs those establishments which are not covered under the employees under the ESI Act of 1948. So there are these two acts which ensure maternity benefit in different contexts of work. It is quite noteworthy that the MB Act does not mandate that a women employee needs to be married to avail these benefits. So marriage is not a ground rule or a guideline within the Maternity Benefit Act, which is pretty path breaking for a conservative society like India. Pregnant women employees working in central governments are entitled to maternity benefit leave of 180 days under the Act. that is 6 months, but now currently it has been extended to 26 weeks in an amendment of the Act in 2016. The Maternity Benefit Act also covers miscarriage and medical termination of pregnancies, getting breaks for breastfeeding, and also if they undergo tubectomy operations, then they get 2 weeks leave with wages at the rate as specified in the Maternity Benefit Act. The MB follows the employer's liability model. So the responsibility of ensuring the economic remuneration is with the employers, and they are supposed to provide the maternity benefit and protection to all pregnant employees, and the employees are not supposed to or not required to make any contribution towards this. So in many ways, Maternity Benefit Act recognizes the reproductive work that women do, at least in terms of childbearing and child rearing. So that's an interesting dimension which has been now extended. And also there is another dimension that has been added, is a 2 years leave, at least in the central government employees employment, that 2 years leave for women in case they want to look after their children till the age of 80. The Employee State Insurance Act covers those establishments which are not covered under the Maternity Benefit Act. Essentially what it provides is cash benefits with regard to sickness, maternity and employment injury, and other medical benefits to workers earning less than 25,000 per month. So there is a ground rule that those workers can apply under this act who earn less than 21,000 rupees per month, and factories which are employing 10 or more workers. So in some ways it actually excludes certain categories of workers who may be earning a little more than 21,000 rupees. And also a factory may not be employing 10, they may be employing less than 10. They can easily escape this particular act. Under this act, the cost of reproduction are borne by all three parties. That is, the government, the employees, and the workers contributing to the ESS. So that means that there is a scheme under this particular act. So the employees have to make part payment, the workers have to make a part payment, and the government is also required to make a part payment to create a corpus of money, and from this corpus various benefits are given to men and women. It's not a women specific women only law. It is available to all workers and categories of workers who are earning less than 21,000. The Act tries to attain the goal of socio-economic justice under the directive principle of state policy, part 4 of the Constitution. The ESI covers the organized private sector of different sizes and production capacities, as well as shops and establishments. What is important for us to remember, that the Maternity Benefit Act largely covers central government employees. It can be extended, and it can get extended into private companies and organizations as well, provided the employer feels it's better to come under that act rather than the ESI Act. So there is a matter of choice between the two, and a lot of employers prefer to use the ESI model because it's a contributory model. The burden and responsibility of providing for maternity benefit does not lie only with the central government in that case. The limitations of the two acts. In reality, the implementation or the benefit of these acts goes only to a limited population of women workers. And it's dependent on the presence of an union which makes sure that the benefits reach the women workers. Unfortunately, the two social security legislations do not cover unorganized sectors and informal economy, and it is quite a known fact that 96% of women workers are in the unorganized sector. So it leaves out 96% of the women workers. Although the Beedi and Cigar Workers Act extends benefits to home-based workers, and there are a few state-specific government schemes which cover agriculture workers, the coverage is very limited and it's very specific to particular contexts and work that women work. And the National Food Security Act now provides rupees 6,000 for per woman, no matter where she is or where she is working, per pregnancy. But it again, there is a problem in terms of implementation and in terms of convergence with various other programs, and systems of implementation are not really in place. The Equal Remuneration Act is another act which is of significance to women workers. This was enacted in 1976, and it mandated that an employer cannot discriminate against women employees in terms of wages paid to them. So essentially this particular act looks at inequalities in wages and ensures that there is no discrimination with regard to the wages that are paid in different establishments with regard to men and women. However, it says that remuneration should be given based on men and women doing the same kind of work or work of similar nature. That is very crucial for us to remember, that this in itself is not very clear a definition, and when it says same and similar, it does not look at the kinds of work that is being performed, and there may be different kinds of work that are performed by the men and different kind of work that may be performed by the women based on the organization's definition of who should be doing what work, which is of course not gender neutral. It is very gender specific and often very gender discriminatory. Hence there has been a movement to demand that the work of equal value should replace same and similar. This would mean that disparate jobs would have to be assessed, evaluated for the value they add to the production process, even if they are different from the jobs performed by another person. This hasn't really happened, and there hasn't been much mobilization around Equal Remuneration Act. Another key factor that we need to keep in mind is, again, this particular act largely applies to women in the organized sector and not so much in the unorganized sector. Night work for women have also been, there has been a lot of discourse and debate historically as well. The Factories Act 1948 lays down that no woman shall be required or permitted to work in any factory except between the hours of 6 a.m. and 7 p.m. with a proviso that the hours may be varied by state governments, provided that no woman may work between 10 p.m. and 5 a.m. However, exemptions in special situations have also been laid down, that they may be allowed to work in cases like fish curing, fish canning factories, where the particular product that is being worked with shall get deteriorated, or it is something that's natural and which will not stay for the entire 24 hours. In that case, women may be allowed to work during the night. So there is an exemption that is there even in the Factories Act for women to work at night. Interestingly, because of neoliberalization and pressures from various competitive industries, several sectors like electronics, information technology, food processing, in agro-industry and textiles have and require women to work at night. So there is a pressure on the state to deregulate the regulations laid under the Factories Act. These sectors require continuous processing and also continuous work. For example, in the BPOs, and a lot of BPO work is now being done by women because of the time difference required by different organizations. Women workers, unlike most male workers, therefore are doubly burdened because they are doing a double shift, because they have to do household work when in the daytime, and at night they have to do night work. So the ways in which neoliberalization is deregulating, is forcing governments and states to deregulate various laws, women are getting doubly burdened in situations and industries like these. And these industries perpetuate the gender inequality in the existing society. There are issues of safety, harassment, violence, because adequate transportation is not provided for, and safety in public spaces is not ensured either by the state or by the society. The last act, which is essentially very path-breaking, though it does not regulate all working conditions of women workers, but it ensures that women are able to work efficiently and at peace, because it addresses violence against them in workplaces. Sexual harassment of women at workplace, 2013, is a very critical act that we need to know in women and labor law. It came from the Vishaka judgment, wherein Bhavri Devi Sathin, who was working in the Women Development Program project in Rajasthan, she was raped because by upper caste men, because she was fighting against child marriage that was highly prevalent in the society, and she had lodged an FIR, and she was trying to prevent a child marriage in the village. To ensure that, and she was doing a very effective work, and to ensure that she is not able to do so, and she should not perform her tasks, and she would not listen to the upper caste men. She was taught a lesson by the upper caste men, and then she went. The horrific rape led to agitation by the women's movements and women's groups in Rajasthan, and Vishaka, an organization working on women's rights, decided to file a public interest litigation to say if women have to work in unsafe situations, there needs to be some rules to protect her from violence. And therefore, the Vishaka guidelines were formulated by the Supreme Court, wherein very clear action needed to be taken against anyone violating a woman's private safety and was harassing her in workplace. This was further deepened after the Nirbhaya case in 2013, when Justice Verma Commission was set up, and this act now applies to all types of establishment in the private and public sector, to all employees, including those who are temporary, casual, contractual, probationer, trainee, interns, ad hoc, volunteers. So it's a very comprehensive coverage of all women workers in all kinds of situations and workplaces. So sexual harassment, as it is defined in the Act, is that physical contact and advances by male colleagues or male persons in the workplace, a demand or request for sexual favors, making sexually colored remarks, including abusive remarks, showing pornography, any other unwelcome physical, verbal or non-verbal verbal conduct of sexual nature is which is an open-ended dimension. So the unwelcome part is by the woman herself. She defines what is unwelcome for her, what she finds as sexually intimidating or difficult. And sexual harassment also includes stalking, persistent efforts to meet, use social media like emails, Facebook, WhatsApp, SMSs, etc., which can malign a woman and also intimidate her and create a hostile environment for her in any workplace or situation where she is working. The Act of 2013 also lays out the possible circumstances under which sexual harassment should be considered. This is very significant because often we hear a lot of comments saying that women often do not women prefer to be treated in this particular manner, or women do not protest. So women need to know that if there is any implicit or explicit preferential treatment that may be given or promised by her employer, then that is considered to be also part of sexual harassment. So if she is invited over for dinner with a promise that, well, I will make sure that you get a promotion next year or next month, or I will post you to a place of your choice, just come for dinner with me, then that in itself, there is an explicit and implicit arrangement out there, a comment out there, or a motivation out there on part of the employer. Implicit or explicit detrimental treatment in her employment. Similarly, to intimidate, harass and tell her that I will demote you, or I will post you in a place where you will not be able to work efficiently, or I will post you under a particular boss who is very demanding and tasking. So in itself that can be construed as sexual harassment. It can be also located in an implicit or explicit threat in her present or future employment. So certain asking for certain favors, sexual favors, saying that, you know, if you don't do this, or if you don't come out with me, or if you don't date with these two men who are coming in for the project and they need to be pleased, then you shall be thrown out of your job, or you shall be there, I will create a case against you saying that you are misbehaving or you are indisciplined. Many of these threats can also become part of the overall sexual harassment trajectory. Interference with her work or creating offensive or intimidating or hostile work environment is another dimension which can be understood and which can be implicated in sexual harassment cases. Humiliating treatment which are likely to affect her health or safety, that she's come back after having a baby and then she is not allowed to take breaks for breastfeeding, or she is not allowed to go home early, and she's also asked to stay back so that the boss can spend some more time with her. These kind of situations, and then of course using abusive language or threatening her in front of all the her own peers, can be many ways in which she can feel that she is being sexually harassed and treated with indignity. So there are some of these possibilities which can be utilized. Sexual Harassment Act lays down very clear procedures. The components of this act is very empowering for women, because there are very clear guidelines as to how this act needs to proceed and how they can be actually operationalized, and hence then it can be very effectively implemented by employers in the workplace, and can also be very affirmative for women to work peacefully in workplaces. The Act lays down that the establishments which have more than 10 employees have to set up an internal complaints committee with a separate one for each office or branch. Establishment with less than 10 employees have to go before the local complaints committee, which is to be set up in every district of every state. These LCCs have to investigate complaints regarding sexual harassment from establishments where ICC is not set up. The complaints committee, be it the ICC or the LCC, has to have a presiding officer who is to be a senior woman employee, not a male employee. And when none is available, the district officer will nominate a member of the LLC or even the ICC. 2 employee nominees and 1 NGO member who is an external member, not part of the workplace, should be there as part of the committee hearings. At least half the members of these committees should be women, and the committee will have the term of the office will be 3 years. So in many ways, the presence of women and also ensuring that a woman is supported during this process is something that can be very empowering for women workers, when they know the provisions of the Act and they know that they have a recourse or a redressal mechanism in place in different workplaces. So while it does not address conditions of work, it ensures that violence against work is addressed in the workplaces. So in summary, in this particular module, laws specific to women have been discussed, and the various provisions which enable women to participate in work. A gendered analysis reveals that most of these laws have a great deal of historicity, wherein women have been largely perceived as producers of labor. Hence, their role needs to be supported and protected. Despite women workers demanding themselves to be recognized as individual workers, not as parts of families or as producers of labors, so far most of the acts have not been able to reach that particular state. The Maternity Benefit Act and the ASIS reaches out only to 10% of the working women, because it addresses women's conditions of work in only the organized sector. And the sexual harassment law has a comprehensive coverage. It covers all forms of work and workplaces, but it is limited only to violence against women, not conditions of work. So these are some of the dimensions that are there in the form of labor laws for women at this point of time, and there's a long way to go to ensure that women's rights as workers, as working women, need to go forward more as individuals and as human rights in the country. Some of the references that you might want to look at is Amrita Chachi's work, who is responsible for maternity benefit, state, capital or husband, the discourses that happened and during that particular period. Lakshmi Lingam's work brings out the problems of maternity benefit and reproductive rights, how it is actually located within the act and argued within the law. And Leela Gulati's article, Female Labor in the Unorganized Sector, actually brings out how most of the labor laws fail to address the situations of exploitation and difficulty that women workers face in the informal economy, and that means 96% of women in the country. Thank you.